Hi, everyone. Thanks for joining us. We are discussing when to fire advisors, contractors, and employees here at Romano Law. Just want to do a brief introduction to our lawyers on the call. My name is Sangeeta Selvaraj. I'm Corporate M&A Counsel. I'm joined with Jamar Creech, who's Corporate Counsel, Uzoma Eze, who's Corporate and Tax Partner, and Dan Braverman, who's the Employment Law Partner here as well. We are going to discuss all the different ways, as well as the legal risks and the legitimate, non-discriminatory reasons for ending a relationship that you have with your business. Okay. Really good point to really note here that this entire webinar and any conversations that you hear on this webinar is entirely for informational purposes. It does not create an attorney-client relationship between us. We are happy to create one with you, but feel free to contact us afterwards at Romano Law for a complimentary client call after this conversation. And then we'd be happy to connect with you and talk more about your specific matter. Okay. At the end of it, we have options for Q&A. Also, we've inserted our own frequently asked questions in here that we've got from other business owners such as yourself, so that you can also be aware of certain hot topics in this area as well. So let's just jump into it. Okay, so what we're always going to talk about is answering these two questions. We're going to talk through advisors, employees, and contractors, and we're going to talk about what's the legal risk. And Dan Braverman, our employment law partner here, is going to talk about that, as well as the legitimate non-discriminatory reason for each of those. Let's get into firing contractors. Our tax partner, Uzoma Eze, is going to handle this as to when to fire contractors.
When to fire contractors. Not meeting deadlines or expectations. Okay, first of all, if you're dealing with contractors, you're dealing with a bunch of people who by definition and by law must be given free rein. So that's another thing. You got to be careful about understanding the difference between a contractor and employee. And Dan's going to get into that, and Jamal's going to get into that. But with an employee, what you have is kind of, you're able to box them in. There's a lot more that you can tell them to do or not do. Once you start doing that with contractors, you risk kind of calling them one thing, but the IRS coming in and saying, no, they're actually employees. And that one is a huge problem. You don't want that. So not meeting expectations or deadlines. When you give someone a contract, an MSA or whatever, the contract and the scope of work should be fairly clear as to what they do. So it should be straightforward. They've breached the contract is more what it is. So I don't even want to talk about firing contractors as much as they breached the contract, and so the contract is terminated for lack of performance. So that's the way to look at it. So the most important thing about contractors and firing them is making sure that when you fire them, they were actually, you didn't fire them, you terminated an agreement pursuant to which they were providing services. So legal requirements, usually you have NDAs that you execute with these people, maybe non-solicitations and some different kinds of covenants that you have in the agreement that pretty much prevents them from doing things that would be injurious to your business model, like taking away your secrets, hiring away your guys, stealing your whatever. So those are called legal restrictive covenants. So you want to make sure that they're not breaching that. Maybe you should send them a letter saying, hey guys, by the way, you did sign 1, 2, 3, and 4, so please don't mess with that. Tail insurance or whatever kind of insurance they were supposed to carry, you make sure you have those. And the letter of termination. The letter of termination is important. And the one thing to be careful with letters of termination is you gotta understand that less is more. Less is always more. Don't say in 2 sentences what you can say in 1. Because one thing that will never happen is for you to be in court or be in front of the workforce and they're asking you for some stuff you didn't say. But the stuff you said can always be used against you. So if you're going to give them, that's why I say call it a notice of breach, a notice of termination as a result of breach. And you would just say, pursuant to your breach of this clause, effective this date, the contract is terminated. Boom, and you leave it at that and keep it moving. Okay. So the scope of work that you hire these people for is important. And there's a whole analysis that you need to do to make sure that just because you call them a contractor and pay them on a 1099 doesn't make them contractors. Same way, just because you call them an employee and pay them on a W-2 necessarily doesn't make them an employee. So there is a world of, this is where your lawyers come in to kind of give you, this is where the Dans of the world will tell you, okay, you're calling it this, but it's actually this. And that classification is critical, because imagine where you were paying someone for 4 or 5 years as an independent contractor on a 1099. What that means is every month you just cut out his $5,000 and just send it to him straight, nothing. And you take the deduction as a business expense, natural. Then after 5 years, IRS said, no, he was an employee the whole time. That means payroll. And payroll is filed every 3 months. So you got a payroll responsibilities, interest, penalties, all kinds of things that have accrued over 5 years that you got to make true to this person. Plus also, it's a huge one. If there's anything you need to know about hiring and firing employees versus contractors, is be very clear who's a contractor, who's an employee.
So it's a great summary, Uzoma. And what's the key warnings that we generally recommend for contractors as well? You know, especially part of firing contractors is also having a very good hiring process for the contractor as well, and understanding the scope of the work that they need to do as well. Clarity in contracts is important. Clarity in scope is also important as well. It's like, what is expected of them? When is it expected? And what type of milestones or work is expected by the deadline of that as well too. Most issues that come up with contractors, especially in the firing side, is they don't meet the deadlines, or they don't meet the expectations of their role that they had initially been contracted for as well. Or they exceed the scope, or they start to ask and they start to do more work and then expect to get paid for that. All of those need to be limited or clarified within the initial contract as well. And Dan's going to get into this as well. Each state has state-specific independent contractor tests as well. The main one, and Uzoma touched upon this, is the IRS test has one as well, and that's a 21-point test, I believe, as well. And then in Massachusetts, they have a 3-point test on top of the IC test as well, too. New York, New Jersey, and other states also have their own stringent or less stringent cases as well. And then we'll get into that. And it's really up to you as a business owner to know what state that your contractor hails from, so that you can accommodate and understand what their expectations are as well too. So it's just not a business decision, it's a business tax as well as a legal decision that you need to be aware of as well, okay? Now, Dan's gonna talk about the actual legal risk of firing a contractor, and then he's gonna discuss the legitimate non-discriminatory reasons that you should have for firing a contractor.
Thanks, Sankita. Great overview, Uzoma. So basically, as far as the legal risk, I mean, we sort of touched upon it, but I think this is the big key. With an independent contractor, you got to get it right. It can't be an employee. It has to be an independent contractor, meaning you have to meet the tests of an independent contractor. If you don't, it can lead to what us employment lawyers call the parade of horribles, right? It's basically, well, let me back up and explain why you get there. Common sense, I always say this when I deal with employees, nobody's claiming anything. No one's bringing a claim against you. Usually when they're employed, everything's going well. When you fire someone, they got nothing to lose. They're going after you. If they have a claim, they're going to come to a lawyer. They're going to see what that claim is, and they're going to bring it against you. And if you have misclassified the independent contractor, that's probably one of the strongest claims they can bring against a company. I have many lawsuits right now concerning misclassification. And it's a lot of times if someone's misclassified, you might owe them overtime because you didn't pay them a salary and meet the requirements to pay someone as exempt, meaning without paying them overtime. So if you're paying them $100 an hour as a contractor consultant and they worked over 40 hours, guess what? Every hour of 40, you owe them 150 for that hour, not just 100, time and a half. And guess what? Under most laws, if you didn't pay it, you're going to have to pay them double or triple the money you didn't owe them. Plus, if they get a lawyer, you got to pay their legal fees, right? And in addition to all that, if the other concern is if you bring one of these claims, most likely it may go to a government agency, or a government agency finds out about it. Then you're now getting audited from the workers' comp in the state. You're getting audited from the unemployment insurance, right? You're getting audited from New York State income tax. You're getting audited from the federal government. Where's the Social Security and Medicare taxes? So we say it's a parade of horribles because it can be overwhelming. So it's very important, both firing and even hiring, to have a lawyer make sure you've properly classified the person as an independent contractor. So the risks are very, very large, right? All right. So next step, we talk about legitimate non-discriminatory reason. Whenever you terminate someone, we can talk about it as contractors. We'll talk about advisors and employees as well later on. You have to have a legitimate, I always say you have to have a legitimate non-discriminatory reason. Besides complying with the requirements of the contract, whatever that may be, notice period, maybe there's a payment if you terminate within a certain period of time that you have to make. That's a breach of contract. You always have to meet that. But I always tell everyone, I want to know what the legitimate non-discriminatory reason, because if somebody gets fired, a lot of times they may say, you know what, this was because of my race. This is because of my religion. This is because I had a disability. Whether they're a contractor or an employee, many states now will allow contractors and employees to bring claims. Used to be only employees could bring claims. Now many states recognize that contractors, especially if you're a solo contractor, meaning it's your own individual business, you're not in a big company, it's just you, but you're classified as a contractor, that you can potentially bring a discrimination claim. And every year, every few months, in every state, you see more and more discrimination claims: race, religion, national origin, age, disability, marital status, discrimination, immigration status, citizenship status, victim of domestic violence status. So there are many ways that someone could try to bring a claim against you. But the way to defeat those claims or defend against those claims, you need to have a legitimate non-discriminatory reason. Poor performance, not meeting deadlines, other clients are complaining about the work that they're doing, not competent, whatever it is, doesn't have the skill set, doesn't have the licenses needed. Things like that would be legitimate non-discriminatory reasons. But key to that is you can't just say it, you got to be able to prove it, right? If you're going to say somebody is being terminated for a legitimate non-discriminatory reason, as your lawyer, and to avoid you having claims, I'm going to say, you're saying it, but is there an email? Is there documentation? Show me the deadline they missed. When was it due? When did they submit it? What documentation do you have? And the most important thing is it has to be accurate. It has to be accurate. The way you prove discrimination, it's kind of very tricky in the United States, but the way you prove discrimination, one of the ways, obviously if you have a recording of someone making discriminatory comments, for example, that's admissible, that way you can prove. But another way to prove it is if someone gives you that, quote, legitimate non-discriminatory reason, why'd you fire me? And it's false, or you can prove it's false, the courts allow, and the government agencies allow the jury or the judge or the administrative law judge to infer that the reason why you gave a false reason is because it was a discriminatory reason. So even if you weren't terminating someone based on discriminatory reason, a jury will be told that they can at least take into consideration that the fact that the legitimate non-discriminatory reason was false, that it could have been a discriminatory reason, not something you want to have happen. The way to avoid that is to make sure you document and have objective evidence of your legitimate non-discriminatory reason before proceeding. You know, contracts is a little tricky because there's the contractor that's paid on a 1099 versus employees paid on a W-2. There also are some contractors that are paid on a W-2. They're like working through a temp agency. They're still considered a contractor. They can also have claims. They won't have the tax-related claims, but they could have claims that maybe they're not receiving certain benefits that an actual employee of the company receives. So for example, if you have a contractor, you don't want to have employees on your books, so you use a temp agency to have these people work for you. There's always an issue if they work for a long period of time. Is there some discriminatory reason why they're not becoming an employee like your regular employees? Should they have been entitled to certain benefits that regular employees have? So again, it's very important to speak to counsel before you establish these relationships, to make sure you start off on the right foot, to avoid claims down the road, because like I said, everything's fine and dandy until you fire someone. I mean, I see it all the time. You fire someone and suddenly like, well, they seem so happy. Yeah, well, you're paying them, they want to keep the business. Once you fire the person, once they know they're being terminated, it's, I learned this over my 30-year career, everything comes out of the woodwork. They're going to give you anything you've done wrong or mistreated them or, didn't pay them properly. They're going to go to a lawyer. They're going to say, what are my rights? And you want to get ahead of that. So hopefully you did have a lawyer to help you set up the relationship, but it's not the end of the world if you haven't. If you want to fire someone, speak to a lawyer before you fire them. Let them know what your plans are. Let her know what your plans are. They will be able to ask you the appropriate questions to make sure we know what the risk is. Based on that risk, we may advise you different ways to proceed in order to reduce the risk or eliminate the risk.
So there's a practice point here. Is the best time to negotiate a contract is in the beginning of a relationship,
Yes.
right? With the contract, understanding that as well too. But I think a lot of business owners also don't know that you also need to have check-ins, milestone check-ins that you
Sure.
can also document and talk through. Is there anything you would want to change? Is there anything we want to discuss at that same time? Because it also puts the CEO in the driver's seat to understand if there's any future problems brewing or any sort of discontent as well too. So it's almost like management, like making sure the oil is still being utilized in a car, or the gas is still being, the car's still running the best way that it can as well too. And
Yeah,
I think
100%.
that's a great way of a CEO. It's a soft part of it. It's an intangible part of understanding of running a company, is to have that open and honest communication with everybody, not just your employees, but just your contractors and anybody working with you, so that you all can have that open and honest communication to actually adjust the contract if there's needed to. Tweaking and adjusting the contract prevents a lot of backlash in the future as well too. Okay. I'm
Exactly.
gonna jump in some frequently asked questions here. Something that comes up is, when and how do I pay the contractor if I terminate the agreement? Okay, so obviously it's not working out. You send that notice of breach, like Uzoma talked about, and at that point, if you have a good contract, it should state in the contract exactly how much and when you should be paid for. So if it's usually up to the date of the termination date. Okay, so at that point, because a lot of times contractors will come back and say, hey, you paid for the whole project. Okay, that's not necessarily true, especially if they didn't A, complete the project, B, they breached the contract, or C, they were not fulfilling the whole terms of the scope of the contract themselves in order that a breach ensued. Okay, so at that point, a big question is, when and how do I pay the contractor if I terminate the agreement? So anybody want to jump in here?
Sure. I'll just give 2 cents and then let someone
Sure.
else, because it makes me think of a very strong point here. When we mentioned about speaking to counsel before you terminate someone, obviously you may want to speak to a lawyer if you're confused from the contract of what you have to pay. The contract should spell out, as you said, Sankita, what you owe, when you pay it, etc. However, if this goes to the point I was making before, you may want to pay more. You're like, why would I want to pay more than I owe? The reason why you may want to pay more, if you came to me and I've done this a few times where somebody came to me and I'm like, this person should have been an employee. You're going to fire them. You owe them 2 months under the contract. Maybe we give them 3 months. But when we give them the 3 months, we're going to have them sign a document thanking them for all their services and having them waive any claims they have, either under employment law or any other laws. And then you can sleep well at night, right? And they're happy because they only expected 2 months, right? And that might even prevent them even from going to a lawyer. So it may sometimes make sense to even offer more than you owe. But obviously, as Sankita says, your contract, if properly prepared, especially prepared before when you're first hiring the person, there shouldn't be an ambiguity. You should know exactly what's owed to the contract, and hopefully there won't be a dispute.
There's also a thing, a
Yeah,
contractor
yeah.
usually keeps hourly time slots or project-based, if it's milestone, at what point these things have been completed as well too. So you'll have some sort of timestamp as to how much you need to pay if you ever have to, nickel and dime them and show exactly when that is. But Dan brings up a great point where you actually overpay, but then have them sign off on an agreement as well too. Now it's up to them to sign off on it, but usually money is a great sweetener on anything at this point, okay? Because this is America. Okay.
Yep.
And then the second question is, do I still owe the contractor any taxes or unemployment? We touched upon this earlier with Dan and Uzoma talking about this, but what is the simple answer to that?
I think the simple answer is what Dan just told you, is make it all go away if you can. Just get them to sign a release that says we are on the up and up and we're good. The taxes is not that much of an issue because it's a contract, or at least on paper, so there's no taxes that concern you. But remember, the reclassification happens. It's not between you and the employee, it's you and the IRS now. Big problem. Also, on whether there are any other things that should be paid, is really, unless we wrote a really good contract at the beginning and we can tell you 100% this thing works, chances are your best bet. And in fact, the reason I wanted to talk is I have a case like that right now. And what Dan was talking about the non-discriminatory reason, is called, in a lot of court, pretext. If you Google pretext, you'll see like it shows up in every one of these courts. The court basically says, well, you said it was A was the reason. Turns out A wasn't true because he wasn't on seat that day. You made a big mistake. You went and documented crap. The person did the thing on Thursday. You recorded it as happened on Friday. It did happen on Thursday, but you recorded it on Friday. and you went to court and said it happened on Friday. We'll be sure it didn't happen on Friday. Right there, that missing link is proof of pretext. And now the jury can make the assumption that you lied, and the only reason you lied is because of discrimination, and it just goes crazy. The point I'm making is you do need a lawyer to look at things like renewal provisions on a contract and little things like that that could make you stuck with a person that you don't want to be. This person was stuck with this employee for 1 year paying $750,000. And we're in court right now. There's no way we're not going to make money on that one.
Thanks, Uzoma. And so this was the warm-up, actually, before we get into employees, actually. But most of you would be starting off with contractors. So we want to give you this in-depth review of how it is, the ins and outs of actually engaging a contractor as well. And so that you can prevent the misclassification for when you graduate to an employee. A good test is annually when you do file your annual report fees and your company taxes, you actually want to take a look through at your contracts. Okay, the ones with your employees, the ones with your contractors, the ones with your vendors, suppliers, we call it a contract refresh. And take a look through and say, is this person doing more time or more projects at this point? Am I under the risk of misclassifying them as an employee? Okay, should they be converted into an employee at that point? So this is a good marker for you every 12 months. It's a great time just because you're going to be doing a lot of the paperwork at the same time. Look at all your paperwork and take a look at all of the people that work with you. It's a great time to even check in on vendors and suppliers. Is it working for you? Should you renegotiate? It's a great time for a contract refresh and to also understand whether you're classifying the appropriate people at that time. Okay. Let's jump into firing any employee, not just part-time, full-time, any employee. Okay. And Jamal's going to take this over and we're going to talk more about it. And then Dan's going to follow up with the legal risk as well.
Yeah, so I won't repeat the test for classifying an employee or anything of that sort, but generally speaking, employees are the individuals that are getting wages and salaries. There's a great degree of control over the work. Look at things like who's providing the tools and the equipment, where's the work being completed, things of that sort. But employees, because of this, and Dan is going to expound on this, but they are afforded the greatest amount of protection under the law. And because of that, you have to tread it lightly when you're deciding to fire an employee. So generally speaking, when would you fire? What would be the appropriate time, or what would be the appropriate things to consider when firing an employee? Number one here, poor performance. They're simply not meeting the expectations under the employment agreement that should have been set at the outset of their hiring. That would be a simple reason for them not to continue with the organization. Layoffs. Oftentimes, companies experience layoffs for a variety of reasons. Normally, financial. They're not unable to pay. They're unable to meet payroll, unable to meet their obligations, and then there's some sort of contraction that occurs, and either that position or several positions have to be cut to keep the company going. Restructuring. So if there's for some reason, the organization has to change, and whether there's divisions that are no longer present, there could be a merger of some sort, acquisition of some sort, and in that process, employees can be fired, and as part of that whole situation. The key to managing an employment process termination is documentation. That is number one. You must have a clear file of what has transpired. And one of the starting points, employment agreement. Got to document who you hired, when they were hired, what they were hired to do, how much they were paid, so forth and so on. That has to be clear. So make sure that employment agreement is in the file. PIIA, which as no, it's not on here, but I will actually give you the name for it. Proprietary Information and Inventions Assignment Agreement, which is a long way of just saying this is the agreement that protects the intellectual property for the organization So if an employee, for instance, invents something or creates some sort of create something during the course of their employment, it protects that invention from being claimed by the employee. So that's just making sure that is in place as well. Code of conduct, these are the policies of the organization. So you want to make sure that, and that's one of the basis for termination. If there was a policy that the employee violated and it's been documented that the employee received or they were aware of the code of conduct, you want to make sure that that code of conduct is present in the file. The employee handbook, essential. And oftentimes it's advised that the employee sign that they received the handbook and the date that they received the handbook. And any sort of updates to the handbook should be provided as well as the all important letter of termination. You want to make sure that the letter is signed and accepted, and the basis for termination is clear. As previously stated, you cannot terminate an employee for retaliation or for any sort of discriminatory reasons, or you can't terminate them on the basis of something that would be void as against public policy. So that's it.
And for employees, Dan's going to talk about the legal risk and what's the legitimate non-discriminatory reason for actually terminating an employee relationship.
Sure. So as far as the legal risk, when it comes to employees, there probably couldn't be more risk, right? I've been practicing for 30 years and I thought employees had rights, but I will tell you, employees have rights now that they don't need, some you don't even want, but you have rights like you wouldn't believe. I mean, you can't, I listed before the various bases of discrimination, but there are so many more laws that have been passed to give employees all these different rights. And you know what, when an employee is terminated, as I mentioned, no one's complaining when they're getting a bonus and got a raise, but if they don't get one, they get fired, they go into a lawyer. They want to know what their rights are. They want to know what they can do. And now I know that I have a whole host of laws that I can look to see what could they possibly have done wrong, or what might they have done wrong, right? Or what does it look like they would have done wrong? So I think it's very important when terminating an employee that you know what that legal risk is. And the way you find out what that legal risk is, you have good legal counsel, you have good human resources professionals, if your company has a human resources professional, and you basically have to do an analysis. And you have to look at, we have to know what the risk is. So we have to know what all the rights are of the employees, and we will assess whether it looks like someone could bring a claim. Is this the only person of a certain race or a certain religion? I had a case, the only woman got fired out of a group of 10 men in the same department. Why was she chosen? She might think it's based on gender. Now, the key here is, doesn't mean you can't fire the person. In fact, you have to fire employees. You have to do it right, properly. You have to fire employees, because if you have incompetent employees, they're going to ruin your business. Right? Your business goes under, but you didn't get sued for discrimination, but your business went under, right? So you gotta move and terminate, but you got to do it properly. And the way to do it is to analyze the legal risk and know what you're dealing with. Once you have that legal risk and we know what the risks are, I'm still going to want to know, and anybody, you have to know also, what is a legitimate non-discriminatory reason? Why are we terminating this employee? And you know what? The legitimate non-discriminatory reason might be as simple as what Jamar said. It might be a layoff. It might be a restructuring. That's not good enough. You know why? Because if you're restructuring, you have a layoff. I have many cases where I said, I understand you had a restructuring. I understand you did a layoff. But why'd you choose my person? Why'd you choose my guy? He just got back from medical leave. He's got the most tenure. Well, he had a restructure. I know you did. You had to terminate someone. He's got the most tenure. He's got good reviews. Why'd you pick him or her? So you want to make sure you have a legitimate, non-discriminatory reason that you're going to be comfortable standing behind and, defending, or, being able to explain it. And I always say, it doesn't have to be objective. It could be subjective, but in my world, if it's not objective, you're asking for trouble. You really want someone from the outside to not be able to dispute your legitimate non-discriminatory reason. And once you have a legitimate non-discriminatory reason, it will make it much easier to terminate an employee and to defend yourself if, God forbid, you get sued. At the same time, when you do terminate, going back to the legal risk, if you want to try to get rid of that legal risk, something that people will sometimes do is they will offer, as I mentioned it with the contractors, they'll offer some severance. If someone worked for you for 6 years and you have to terminate them, restructuring, you might want to give them a week or 2 weeks severance for each year of service. You might, they worked there for 6 years. They helped you out. They're not being terminated for performance or anything misconduct related, et cetera. In which case you would give them the severance. But most important thing is, whenever you give someone severance, in my view, you must get a separation agreement signed where they waive claims against the company.
That's great advice,
Yep.
Dan, actually. And just thinking forward as well, too, every time that you're negotiating that severance or actually just giving them the severance agreement, saying we'll give you X dollars for this Y agreement. Part of that is also making sure that you're thinking ahead for the next 2 to 3 years, almost up to 5 years. Like, what can you lose if a lawsuit is brought to your company because of an employee or a misclassification or so forth? So you have to think forward to think about what you can afford right now to make that problem go away, right? So like it's an investment rather than a payout at that point.
Right. Yeah. And let me add on that. It's an excellent point. We talked a little bit about for the contractors, how the parade of horribles, but we didn't talk about what can employees get. So just real quick, briefly, what they can get if they bring like a discrimination lawsuit in almost all states, I think every state. If an employee succeeds on an employment discrimination case, because you didn't have your ducks in a row, you gave a legitimate non-discriminatory reason. And as Uzoma pointed out, it was deemed to be pretext. Even though you didn't fire them because of discriminatory reasons, that was deemed pretext. And the jury said, you know what? Well, we think you fired them because of their race or their religion or their disability leave. Now, what can the jury award you? The jury can award them the lost pay that they've lost as a result of being termination. The jury can award them all the attorney's fees. So all the time their lawyer spent to the employee's lawyer spent prosecuting the case, they keep track of their hours. That could be hundreds of $1,000s. You'll owe that in addition to the lawyer fees that your lawyer spent. So you're paying your own lawyer's fees and you got to pay their lawyer fees. In addition, you may have to pay for the emotional distress that the person suffered. You might have to pay punitive damages, which is damages to punish someone for, treating someone badly. When it comes to these cases, it could be a small company. It could end the company. I'll put it that way. It can be very large damages. Most states, there are no caps. So you get a jury that is very sympathetic to the person suing, they can award unlimited damages. So this is something that I tell people that it's very important to properly terminate someone, to avoid those issues. And one thing I'll end by saying this, that the saddest thing or the most amazing thing, I guess, is in my experience, is that I always have all these cases I've had for so many years, and I'm like, wow, this could have been avoided if this little thing was done differently, right? This little thing done differently, like the smallest mistake could lead to huge damages, huge. So it's something that it's not necessarily a lot to do it the right way. But if you're doing it the wrong way and you don't care, it can look really bad. And you're going to get some jury that says, well, you treated this person badly. You had pretext for this reason that you terminated them. And they really feel sympathetic for this person who was on medical leave for cancer. And they said, you know what? I'm going to sock it to that company. We can award punitive damage. Oh, no limit. Let's give her a couple $1 million. Why not? And, emotional distress, same thing, $1 million. So, I mean, there's high risk there. So it's something that's got to be taken very seriously, throughout the United States.
So this is a great lead-in actually to our most frequently asked question on this is, should I have an offer letter? And let me tell you, an offer letter is like 1 to 3 pages. Okay, that's it. It's a little drive-by. Okay, or a full employment agreement, which can go up to 9 to 15 pages, depending on all the exhibits and so forth. You can kind of gauge what exactly it is by the length of the contract sometimes. Okay, but Dan, this is a big one. This is a really big one here.
Okay, so, and I'll answer this in full disclosure. All I do is employment. I've done it for 30 years, but I represent employees and I represent companies, right? Mostly companies, but I do represent employees as well. Probably 60-40, and it changes year to year. But ultimately, so if I'm representing the employee, I want an employment agreement. If I'm representing the employer, I'm like, only offer letters, all right? So the way it works, my view is this. You basically, in my opinion, you want to basically have that they're an employee at will. They can be terminated anytime, no reasons asked, etc. Now, some people ask, what about certain, like if I want to give them stock or equity for employees that are, offer letters, etc. in an offer letter? I said, well, you can still put contractually binding terms in the offer letter, but you're not going to give them a full-blown employment agreement, which really is reserved, only for the top, the key employees, the ones that you want, the CFO, the CEO. You usually don't see in the United States, employment agreements for anyone other than the C-suite. You could, maybe the top engineers too. Everyone else usually gets an offer letter and they don't have rights to severance, etc. Doesn't mean they're not going to get it. It just means they don't have a contractual obligation. They may have a few contractual obligations, such as sign-on bonus. If an offer letter might say, we're giving you a $50,000 or $100,000 sign-on bonus. If you have to pay it back if you leave within a year. If the person doesn't get that bonus, they can sue, breach a contract, even though it's an offer letter. So it's still an agreement. It's just an offer letter is generally seen as a much simpler document. Employment agreement is a whole different world. Like I said, again, if I'm representing the employee, I'm trying to get the employment agreement. I will tell you that some people could speak on this also. I know that like for my clients in the UK and France or international, everybody gets an employment agreement. Our employees in the US, they have rights. They have a lot of rights they don't need, right? We don't want to give them a lot more. We don't want to make it more difficult if we can avoid it, right? You're not taking anything away from them. It's just they have all the rights. The law grants all these rights that some countries make you have a contract in order to get. So I think it's important. But again, my preference is offer letter, definitely from a business perspective, as from the employer side.
That's also important too. So we touched upon this before, and Jamar brought up a point in our chat, is what about key employees, right? Like all of us on this call have negotiated contracts for key employees or high level employees that are either coming in as CEOs or CFOs, especially with stock options or phantom rights or vesting options and so forth. And so those do need the extra paperwork, so to speak, and then those rights that happen. And speaking as an M&A lawyer, I want to make sure that my company is also going to lock in some key people, because that makes me so much more attractive to a future buyer to have those employee contracts in place. So by the way, employee contracts are considered saleable assets, which makes the value of your company go up because you have these certain key employees set in too. So it's a strategic call as well too that you need to have with the employee attorney, as well as, you know, your corporate M&A counsel, to talk about, where's this employee going to be in 3 years? In 2 years? Are they going to be there when we try to sell the company? Or will their stock be completely vested by the time that we try to sell the company? Are they going to have any voting rights? These things should also think about when you're thinking about high level employees. But if you're someone that's just having some like a part-time employee come in or something on a lower level that, you know, could graduate, of course, you want to just have a different scenario in place at that point. But everybody that is employed at that point becomes a saleable asset if you have a contract in place. But all of this to say, an offer letter and employment agreement still needs to be in a written document, okay? It's not a handshake, because that's only when your company goes up, is if somebody, a future buyer, can see those contracts in place and say, okay, you have this staff on right now, and that's who we're going to buy right now to fulfill and continue our company as well. We are running short on time, so let's actually move forward. We've had a riveting conversation about this, and any questions that you may have, please also connect and have a complimentary call as well. Jumping straight into advisors who have no rights. Okay, technically they are operating almost as ad hoc in between, and if they're getting compensated in such a way, they may fall under independent contractor side, but we'll see more about how that advisor agreement looks like. So why do you have an advisor? We talked about it in our last session as to why you need to hire an advisor for the growth of your company. However, advisors are short-term. Okay, just because your company grows, as your company grows and evolves, the type of advice that you need also should evolve with it, right? So you need to prune, curate, and evolve your advisory board as you also grow. Okay, so when to evolve? When that advisor has outlasted their value. Okay, we don't want to say it like they're, you know, off to the desert at this point, but basically that their specific role could be strategic or long-term. Long-term advisors usually sit on top and they give long-term advice about the future of the company, how they would see it, something like your attorney and your accountant and some sort of financial advisor are usually long-term advisors, just because they're here for the long-term health of your company. A strategic advisor is someone that's very good at scaling a company for a specific amount, or a launch of a specific product in your company, or you bring them on because, say, you are trying to get through for FDA compliance and they are an expert on FDA compliance. So you bring them on for a stint of 3 months, 6 months, or so, however long you think that their need is, okay? And who to always include, of course, CPA attorney, a business advisor, probably a business broker, okay? Because they're thinking about the future health of your company and whether you might sell at that point. Documentation, you know, in our world, it doesn't exist unless there's a contract, okay? So there has to be an advisor contract with an NDA. NDA is a complicit in that fashion. So NDA is a non-disclosure agreement. Sorry, a lot of discrimination today, is a street word for confidentiality agreement. Now, that can be a full agreement or it can be a clause within a larger agreement. It's pretty malleable and flexible, this NDA term. So what that allows you to do is speak freely about where you're trying to go, what you're trying to do with the company in order to solicit their best advice. And compensation terms, hourly or advisory shares, or a hybrid situation where they can give you a quarterly calls and you would pay them $1,000 per quarter. But then you also give them maybe 1% of the company if they fulfill those 12 months as well, too. All of this has to be outlined in that. Now, if they don't make that milestone of 12 months, they don't get the shares. That's simple. Some people are paid hourly. Some people are paid for the whole time that they are together or they're part of your advisory board at that point. Same thing applies. Letter of termination and notice as well, too. Again, if they're not expecting anything, then it's easy just to terminate that and just go from there. If they only do 2 quarters, that's it. You've already paid them for the 2 quarters, okay? But if they're supposed to get advisory shares at the end of 12 months, they don't get any of those advisory shares because they haven't fulfilled the full 12 months, okay? Big thing, business practice point here, check with your roadmap. In the end, you're the one that decides the validity of your advisor's advice and their role on your advisory board. And they should be running parallel with your growth of your roadmap, of your growth of your company as well too, and thinking strategically long-term as to who to bring on for the next 12 months and so forth. We generally advise that you bring on advisors for anywhere from minimum of 3 months all the way to 12 months, and then renew. And most advisory contracts allow for renewal clauses if you want to bring them on, and then you can renegotiate that contract as well, okay? And Dan, we can touch very lightly on the legal risk as well as the legitimate non-discriminatory reason for advisors.
Yeah, I mean, it's really similar to what we've discussed. I mean, there's less generally of risk from a discrimination standpoint. They're not employees, obviously the advisors. They can be contractors, as you mentioned, which could raise some issues, but those risks are less. I think the bigger legal risks with advisors sometimes might be reputational. There might be, ruining relationships. There might be a lot of practical or political reasons why you might want to navigate carefully and end these relationships in a most respectful manner as possible, right? It's always good to end this amicably, right? But obviously it's got to be clear in writing that they're not getting paid anymore, that they're not going to be advising anymore, that they're not going to be telling people that they're still giving us advice, right? There's you want to separate fully, it's like, well, your advisor, I haven't worked with this person in years. Well, they say you're still your advisor, right? Whatever. So you want to make sure you do that. But then it always goes back to the legitimate non-discriminatory reason. And briefly, anyone these days, like any in a contractor or employee type capacity, can bring a claim against someone, even in a pure contract perspective, if you're just two businesses, if they have discrimination. So you always want to have your legitimate non-discriminatory reason. And exactly what Sankita said, you could say it maybe a little nicer, but you bring no value anymore. Your services, we really appreciate what you've done for us. We've grown a lot. We couldn't have done it without you. That might be a better way to say it, but
we'll work on the language. Yeah,
exactly. Sorry, I have no more value here. No, but so I would say that that's something to just think about how, you could end it, but that is a legitimate non-discriminatory reason. Having no value is a legitimate non-discriminatory reason. It's just by saying it in a nicer way, it might avoid someone thinking about bringing a claim. So that's really why you still want to have your legitimate non-discriminatory reason at all times, no matter what, whether it's an advisor, employer, contractor, the same rules apply.
Frequently asked questions, I'll cover this. What if I give my advisor shares in my company? Can I still actually, can I still fire him or her? Absolutely. It's at will. Go ahead and fire willy-nilly, okay? The fact of the matter is you can fire at any point that you want. You just, like Dan perfectly summarized, is you have to have a legitimate reason and you have to have a non-discriminatory reason as well and understand your risks at the same time. Okay, so what if the advisor already has shares in your company? Great. We have to find out if they're vested already. If they've already been vested, then they actually have ownership in your company. Sometimes we include something called pay to play, pay to stay clauses, okay? What that means is if they leave the engagement or they leave that support role as an advisor in your company, they've got to sell back their shares, okay? That's a great way to keep your company clean, keep your shares with everybody that is adding value, as Dan so eloquently talked about, and then to also talk about, so you don't have shares running willy-nilly and you can't, they don't come up, or if they're non-voting or whatnot. So understanding exactly how advisors get shares, and then also how do they give up the shares is also important before you give them away as well. Also something we can talk about when you book your call. Finally, key takeaways and next steps, and we'll wrap it up here. Document. Again, our world does not exist unless there's a document, okay? And we need to know whether you have signed a contract, any fashion, okay? Even that offer letter needs to be signed. All right. Whether you have signed a document with that person, whether in the contractor, employee, or advisor role as well. But before we do all of that, vet these people hard, and then keep vetting them. Okay. 6 months, 12 months, that, annual refresh, take a look at what that conversation is looking like. What does their work look like? Is it time to engage a new employee? Is there time to bring in a new contractor because this one's performance has been lagging so far? Okay. And then timing is everything. Timing is very important, okay? Understanding why you're going to fire this person, as well as the correlation as to when you fire them. The decision to fire and the decision when to do it might not be at the same time. So understanding what that appropriate decision is and being ahead of that is important for strategic value as well, too. Okay. And wrapping this up, coming next, stay tuned. We're going to tell you, and we will put it out on LinkedIn as to our next webinar, which is monthly, and our next one will be coming up in early October. And again, as always, feel free to contact us for a complimentary call at Romano Law PLLC. Thanks so much.